Are you allowed to secretly record people at work? Can you use your phone and videotape your gross coworker? Can you use the audio capture and secretly record your sleazy boss? Is it legal to do that? We're going to unpack and answer all of those questions in this whiteboard video. We're first going to examine the basic law regarding recording confidential communications in the workplace. We're then going to break down what is and is not a confidential communication so you know what you can record and what you can't record. And finally, we'll unpack what to do if you've recorded somebody in violation of law. My office has received hundreds of phone calls from employees up and down the state of California saying something like this. My boss was sexually harassing me, so I got my phone out and I hit record, and now I've got smoking gun evidence of the sexual harassment. Unfortunately, you don't, because California Penal Code, section 632, subsection A, says that it's against the law. Specifically, it says, a person who intentionally and without the consent of all parties to a confidential communication uses an electronic recording device to eavesdrop upon or record the confidential communication shall be punished by a fine or a short jail sentence. Now, pause. Before you freak out, at the end of the video, we're going to talk about what to do if you've already recorded your boss or coworker in violation of this law. So don't freak out. But secondarily, this law is important because what it says in 632 subsection D. It says if you record somebody in violation of this statute, you can't use it in any judicial proceeding. So there really is no point to recording your coworker or your boss. And in fact, it more likely than not hurts your case because it technically is a crime. Well, okay, so you can't record anything? Not true. Section 632C defines what is a confidential communication. So let's figure that out now. California Penal Code section 632C defines what is and is not a confidential communication. Specifically, it says confidential communication means any communication carried on in circumstances as may reasonably indicate that any party to the communication desires it to be confined to the parties thereto, but excludes any communication that is made in circumstances in which the parties to the communication may reasonably expect that the communication may be overheard or recorded. Okay, what does that mean? Basically, you cannot record if it's reasonable indications that a party to the communication intends it to remain confidential. However, if there's no reasonable expectation that the conversation can't be overheard or maybe there is a recording, then you can record. So let's break it down in some hypotheticals so you can understand this a little bit better. Let's say you're working and your boss calls you into his or her office and closes the door. Well, just by closing the door and in a confined space like your boss's office, there's reasonable indications that your boss intends it to remain confidential between the two of you. Okay, well, let's change it up. What if your boss calls you into a conference room and HR is there as well? Well, likely again, in the conference room where the door is closed, it's going to be very difficult for anybody to say, well, that could have been overheard or recorded by somebody else. So again, you cannot record there. But if the door is wide open and it's common practice that people walk in and out of the conference room, or it's a very big conference room and other people are working in there, well, then maybe you can record. It just depends on the circumstances. What about if you have a group meeting at a park? Say 10 people at a company go to a park and have a meeting at the busy park. Well, it'll be very difficult for the boss to say, well, I intended that communication only to remain among us employees because it could have been overheard or recorded. Likewise, if your boss takes you to a baseball game and the two of you are sitting down eating a hot dog and there's a lot of other fans around and he's talking out loud about this girl or that girl, well, it's going to be very difficult for the boss to say that that was a confidential communication because it could be overheard. Last and final example, what about a wide open cubicle area where 20 plus people work? Well, it depends. If somebody walks up to you and is whispering to you about one little thing, likely that communication is supposed to remain confidential. But if your boss walks into an open-aired cubicle and yells something where 20 other people can hear, highly unlikely that that boss has any reasonable expectation that that communication is supposed to remain confidential. Okay, what if you've already recorded somebody and because you're watching this video, you now know that you shouldn't have done it? What should you do? Well, first and foremost, don't freak out. People break this law all the time. And I've never heard of an employee getting in trouble for violating this law, meaning a prosecutor actually prosecuted them. But that's still not a good reason to do it just because I've never heard of anybody getting in trouble for it. Remember, it is a crime and that generally hurts your case. And number two, you can't get the evidence admitted anyway, so definitely don't do any more recording if you have. Number two, don't delete it. Destroying evidence is a fast track to destroying your credibility in a case. Don't ever destroy any evidence, good or bad. Third, along with that, don't ever lie about the recording. If your lawyer asks you for the recording or asks if you've ever made a recording, admit that to your lawyer. You always want to be honest with your lawyer. Secondarily, if you're at trial or in a deposition and you're under oath, never lie about things that you might have done that kind of hurt your case, like making a recording. It's always better to be honest than to lie in a court case. Finally, if your lawyer asks you for it, give the recording to your lawyer in its native format. Always listen to the advice of the lawyer that you choose. Okay, I hope this information has been helpful. Take care.